and welcome to Chapter 4, Legal Traditions. This is the chapter that really gets us into more of the meat of a comparative criminal justice class. The first three chapters hopefully will provide a background on criminal justice, comparative systems, and law in general that we can then start applying in a more specific fashion to different legal traditions, as we will discuss in this particular chapter. The first thing we need to do, however, is to distinguish legal traditions from legal systems. As you see on the slide, when we're talking about legal traditions, we're talking about a broader category. It includes such things as cultural ideas about what the nature of law might include, what role law plays in societies, what is the preferred manner of organization of a legal system. We'll see some examples of that later when we talk about policing, for example, where some countries prefer to have a national policing system and others a more decentralized system. And much of that decision is not just happenstance, but instead is something that is linked to the traditions, the ideas, cultural ideas from that particular country. Legal systems, on the other hand, are more specific. Reference here is to a country's legal institutions, the particular procedures and rules that are set up by that country. There can, of course, be a number of legal systems that share a legal tradition. The example that comes immediately to mind for most of us would be the United States, England and Wales, Canada, Australia, any of the other former British colonies share a legal tradition that we'll be identifying in a few moments as the common legal tradition, but each of those has a different legal system. Now, having said that, the United States and Canada certainly have a different legal system, but they share the common legal tradition, and because of that, they have more similarities with each other in the way that the criminal justice system operates than would two countries from different legal traditions. Take our southern border, for example, Mexico, and we find that Mexico's civil legal tradition contrasts quite significantly with the United States' common legal tradition. So we need to keep in mind then that the legal systems will differ even though countries might be part of a similar legal tradition. Some points to remember as we're going through this. None of the legal systems offer a pure example of a particular legal tradition. So we can't point to England, for example, as the best, or certainly not the only, but not even the best example of the common legal tradition. Even though it originated in England, there's enough variation that occurs in other countries using the common legal tradition that we can't identify one particular country, even where it originated, as being a pure example. We'll see the same thing with France, for example, which is oftentimes identified as being an extremely good example of the civil legal tradition, and that is a true statement. But even so, we shouldn't say that it's a pure example of the civil legal tradition. Combinations of the traditions are also common. This is especially true in countries where other countries have colonized the country and affected their indigenous system. And if there have been several different types of colonies, colonization occurring in a country, of course that also sets up the opportunities for there being quite diverse systems of law enforcement and adjudication and corrections. We'll see some examples of that a little bit later as we get into it, but just kind of keep in mind that these combinations are certainly possible and quite likely. You see an example of that at the beginning of Chapter 4 when I'm flipping pages right now to get to that area. I apologize for not having that in advance. But on figure 4.1 gives you a good example of how you can combine different types of legal systems. So reference is made to civil common traditions, common Islamic traditions, civil Islamic traditions, and so on. And in that manner, we are reflecting the different combinations that are possible. Regarding the Islamic system, I would encourage you to take a look at the Module 5 folder and also the You Should Know box, and read about applications of Islamic law in different places. This is a good way to get an example of what's being talked about here, this idea that the Islamic legal tradition, for example, we can't identify any particular country that is a pure example of the Islamic system. There's as much variation in the way that Islamic law is handed out as there is among, for common law, common legal tradition, civil legal tradition, etc. Okay, so here are the 4 legal traditions that we're going to be looking at in this particular chapter and throughout the textbook, actually. It's possible to have more. Your textbook points out that depending upon who the author happens to be, there could be as few as 2 or 3, there could be as many as 14, 15 different traditions that one identifies. For our purposes, we're using these 4, and the reasons for that are explained a bit in the textbook chapter as well. Along with those 4 legal traditions, I've identified some building blocks or sub-traditions that help us understand how each tradition was started, what kind of things still influence those traditions. We see, for example, under the common legal tradition, feudal practices, custom, and equity become very, very important aspects in us understanding how the common legal tradition came about. Under civil legal tradition, Roman law, canon law, and codification are identified as the primary building blocks of that legal tradition. For Islamic tradition, the Quran and the Sunnah, as well as Ijma and Qiyas and the schools of law are identified. Let me mention now for a moment that I do not know for sure pronunciations for Islamic words. I don't speak Arabic, so I apologize to any of you who do happen to speak Arabic for my pronunciation, or more likely mispronunciation, of some of those Arabic words. Under the Eastern Asia tradition, Confucianism, collectivism and context, and legal and formalism are identified as the important building blocks. These are, as we will see, key ingredients for each of the legal traditions. They are elaborated upon in your textbook, so I'm not going to do so again here. There are some other things I wanted to spend time on. But please be familiar with each of those sub-traditions and get an idea for how or what role they played in the creation of the overall legal tradition. When we're comparing the traditions, there are 3 primary ways in which that comparison can be carried out: using cultural components, using substantive law components, and using procedural law components. Again, as your slide points out, when we're talking about the cultural component, you'll see that coming about in our discussion of the sub-traditions and also in Table 4.2 of the textbook. You can see some examples of that. The cultural component is important, but again, I'm not going to spend any time on it in this PowerPoint lecture. I believe that the substantive law and procedural law components are a little bit more important for clarification, and want to spend time there instead. So let's take a look first of all at the substantive component. The idea here is asking the question, where do laws come from? In doing so, we're interested in, again as you see on the slide, the primary source of law. And that primary source can be either custom for common law tradition, codification under the civil tradition, divine revelation under the Islamic tradition, or the principles of Confucianism under the Eastern Asia tradition. Now once again, some other author might have another way of phrasing this, but I think it speaks pretty well and clearly as a way to identify and compare and contrast these 4 traditions using just one primary feature. That is, where do these traditions seem to see law as emanating? And what is the primary source? So when we're talking about the common legal tradition, custom clearly has to be the primary source of law. Law is seen under the common legal tradition as being an expression of the the entrenched ideas about what is right and what is wrong by members of a community. Again, your textbook elaborates on this a little bit, but basically the idea is that when William the Conqueror came into England and tried to set up a legal system that was common throughout his newly conquered lands, one of the things that he made sure he did, very wisely so, most people would agree, was to incorporate the local customs into the legal system that he was setting up. He did this believing that it would be important to get a buy-in, for lack of a better word, from the members of the community to his new system, to his monarchy. And that idea has stayed, so that today, in all those countries where the common legal tradition holds sway, we believe that custom is being reflected in the various decisions coming from the common law and the common law courts. This differs from the civil legal tradition, where codification is seen as being the primary source of law. That is, law comes from the written code as it has been provided by whoever's in charge, typically the monarch or the rulers, or more recently the legislators. In this sense, if you're under the civil legal tradition, law has the ability to change, more so than it does under the common tradition, and certainly more than under Islamic tradition. Because laws come from codes, and because codes can change, then the idea of new codes coming about and laws changing isn't so foreign to those people under a civil legal tradition. If you understand the source of law as being something that is provided to you by your legislators and not something that is built into the customs of society, then it's not surprising and much more accepting, or able to be more accepting of, the idea that a new code, criminal code, or code of criminal procedure has been created. This is covered in your textbook, and we'll see some better examples of this when we get into some of the later chapters. The Islamic legal tradition has divine revelation as its primary source. That is, law comes from God, from Allah. The idea is that law has the authority of God. It isn't something that was just part of custom. It isn't something that just developed out of tradition, nor was it a directive from the rulers or the legislators. It's something that God has handed down, and as a result, the source of law is divine in nature. That, of course, has very important consequences for the way that law is interpreted by contemporary Muslim jurists. The idea that since law comes from God, and humans don't have any business changing what God has provided, makes the Islamic tradition, some would say, rather stagnant. That gets us into our next slide regarding flexibility. But it does become rather difficult to change something that God has handed down. The Eastern Asia tradition is based on the principles of Confucianism. Now, as your textbook explains, the ideal here is that within each individual are the principles of law. So the source of law is within us individually. Now, realistically, we have to have some kind of model upon which those behaviors, the desirable behaviors, can be based. And this is why, as the slide points out, realistically, the source of law lies in the codes that are presenting models for behavior. But again, the idea here under Confucianism is that the leaders of a society have as their obligation to present ethical and moral behavior for others to follow. And as long as the leaders are behaving in a moral and ethical and upright manner, they provide this model for everyone else. And in this way, the society as a whole, all members of society, come to have this idea of law as it's conveyed through Confucianism. We'll talk again a little bit about that as we get into some of the specific examples from some of the Asian countries. The other area to use as identification is the procedural component. Here the idea is that in order to be effective, laws must be kept current. And the chart that you see looks at how flexibility of the law is provided. Under the common legal tradition, flexibility is provided under judge-made law, or the allowing of judges to make law. This becomes controversial in a variety of ways, but it also provides a sense of flexibility. Even though the source of law is custom, judge-made law provides us to look at particular cases and apply that, or have the judge apply that idea of tradition to a new instance. Works in procedural law, for example, when previous court decisions have ruled that, let's say, the police might be able to look into an unlocked briefcase in the backseat of a car that's been pulled over for some kind of violation. A new case comes before the court, and here the briefcase is locked. The court is then asked, is it legal, is it procedurally legal for the police to look in a locked briefcase in the backseat of the car, even though we already know it was legal for them to look into an unlocked briefcase? Well, this particularization allows judges to keep the law flexible as new technology develops, as new procedures develop, and in this way the common legal tradition is able to provide flexibility and account for new situations. Under the civil legal tradition, the variation in reasoning and definition provides a source of flexibility. For example, under the civil legal tradition, judges are allowed to identify issues as being either questions of law or questions of fact. And since the judges have the ability to make those distinctions, that's going to allow them to have different kinds of rulings depending upon the issue before him or her as being one a question of law or an issue of fact. And that type of flexibility then allows the civil tradition judge the ability to define the questions or the issues in one of these two ways, and depending upon how he or she makes that definition, is able to make rulings that are more flexible than they might otherwise be. The Islamic legal tradition isn't very flexible. There was at one point the process of ijtihad, or independent reasoning, which allowed some Muslim jurists to independently decide how a particular case should best be interpreted under the Quran and the Sunnah. In the 10th century, that process presumably was shut down. The idea was that all the needed interpretations had already been made, and the doors of ijtihad were closed, as it is said. There are some Muslim scholars who believe that it would be desirable to open those doors again and to allow more independent reasoning by Muslim jurists, but that has not yet been done. And to the great extent, Islamic law is still less flexible than the other three legal traditions are. And some would even say that the lack of flexibility has resulted in some stagnation of Islamic law. The Eastern Asia tradition, here reliance is on informal procedure. We'll see some good examples of this when we get into the chapter on Japan and some other examples as well. But this reliance on informal procedure is seen especially in the cases of China and North Korea, where the informal procedure extends to include vagueness in even how the laws themselves are written. So not only procedural, but also substantive kind of changes. And again, we'll see some examples of that. If you have very, very vague laws, this allows, as you can well imagine, for a great deal of flexibility on the part of the police or the judges. The more specific the laws are, presumably the less role there is for flexibility. Well, that gives you an overview of the substantive and procedural components. And I think with this background of the four legal traditions, we now have a basis upon which we can move into some of the material covered in Chapter 5 on some of the key legal points, and also the chapters on police, courts, and corrections, where we will see how each legal tradition or countries following different legal traditions might be able to carry out those various procedures of law enforcement, adjudication, and corrections. Thank you for your attention.